motion to enter adjudication of guilt and revoke community supervision, and First Amendment motion to enter adjudication of guilt and revoke community supervision with your attorney. Did you understand? Hello, Mr. Holguin. All right, why is your daughter not with us? I'm used to seeing her now. Is she back in school or studying?
You need to talk to her. She took the LSAT.
Yay!
Giving up to take any different. I'll tell you something. I think she did great, but she really suffers.
No, because do they still do that? I remember they said if you took the LSAT and then you did another one, then they would just average it. You can't just say, they don't do that anymore? Oh, you can take it as many times as you want to?
You can only take it 5 times.
Oh.
I'm not up on the rules, but I know the rules have changed.
I challenge all of us to take the LSAT again. It'll bring back memories. Bad memories, right? All right, so on this case, are we here on a motion to revoke? What are we here for?
We are, Your Honor. We're here on a motion to revoke, and I believe the state filed a motion to amend the motion to revoke, and it was filed on September 29th. Yesterday.
All right, just 1 second. Okay, there's nothing attached to this.
He said that the DA's printer has been lost ink and it was emailed to them.
I'll accept. I'm fine with service by email. If that's okay with you.
Okay, all right, thank you.
I wrote it on there too, Judge. Email to the best guy.
All right, thank you.
We're working on getting the ink restored.
All right, thank you.
Part-time to the county judge.
All right, thank you. And then on Holguin, I don't have the motion to revoke file. Holguin. Oh.
Should be printed out there.
Right, all right, got it. And so,
buckle up, guys. Today we're stepping into a tense courtroom where probation revocation hearing takes an unexpected turn. What begins as routine legal talk quickly set the stage for a high-stakes battle over a man's future. The judge wastes no time sorting through missing files, amendments, and confusion, making it clear this case isn't going to be simple. The atmosphere is calm on the surface, but the tension underneath is undeniable.
it's set for today, and what is the issue?
Your Honor, the first amendment was filed yesterday. This is the first chance I've had to get to talk to my client. I was wondering if I could have some time to prepare him and talk to him about this case.
All right, do you have the original motion to revoke? Because I only have the First Amendment. Where's the original?
Would a copy suffice?
Rashad is bringing it.
Oh.
Thank you. We made it. So the only thing that I see that's been added is a possession of a controlled substance.
Yes, Your Honor, that's one of the new number one.
All right, do y'all have labs for that?
We do not. It just occurred.
Then labs, are y'all expecting to have those labs in 10
No,
minutes?
I told counsel there's no way we'll get those back anytime soon.
So then the First Amendment really has no bearing because they're not going to be prepared to proceed on the violation of condition of number one, possession of a controlled substance. So I don't know why it was added. They don't have any labs for that. They're not going to have labs for that. And it'll probably be 6 months or whatever before they get labs for that. So really the only thing that's going to be proceeded on is probably the original.
The original.
Yes.
Can we on that right now? Yes.
Steve?
May I see the?
Yes. And just mention the one thing.
Sure, Your Honor. Yeah, we just so the court knows, on the original, the other new number one, the evading, was dismissed by our office. So literally the only thing left is the number two.
Okay. Can I have a file stamp, please? Yes. So is this a case that criminal trial division or is family violence going to handle? Because there's nothing that will be left in here that is criminal trial division. The evading has been dismissed.
Your Honor, my understanding before that was the discussion is that we were going to handle it, but I haven't conferred with family violence since.
All right, if you want to confer maybe with family violence, because it appears that the only thing on this motion is going to be failure to submit.
And we're going to plead true to it.
Okay. So I don't know if who's going to be making the recommendation on their side.
Here, the focus shifts to the heart of the case. The state presents its amendments, but they stumble. No lab reports, no solid evidence for new charges. The judge quickly calls it out, dismissing what can't be proven and narrowing the case back to the original violation. This is where the suspense builds. The defense knows the weight of the charge, and the judge signals that only one violation truly matters: failure to submit to testing. The stakes get sharper.
Your Honor, I'll proceed on.
All right, the court is calling 2024 CR 007778, State versus Christian Grant Holguin. Can I have parties announce?
Melissa Albin for the state.
And Eric DeWalt, I represent Mr. Holden.
And are you Mr. Holguin?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and First Amendment Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, I did.
Are you the same Christian Grant Holguin who was placed on deferred adjudication in 2024 CR 007778 for the offense of assault family household member impeding breath or circulation on October 31st, 2024 for a period of 6 years? Is that you?
Yes, ma'am.
All right, state.
You can proceed on number 2, Your Honor. On or about the 15th day of August 2025 in Bexar County, Texas, the defendant Christian Grant Holguin did then and there fail to submit to drug testing as directed by the supervision officer in violation of condition number 2.
How do you plead to that? True or not true?
True, Your Honor.
State.
We'll waive the rest, Your Honor.
Any objections to the waivers?
No.
Did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to $10,000 fine?
May I speak on that?
Now, my question is, do you understand
Yes,
that?
ma'am, I do.
Knowing that, do you still wish to plead true to violation of condition number 2? Court will find violation of condition number 2 true. Is there a proposed agreement?
My understanding is there is not, Your Honor. The state is recommending that we follow the probation department's recommendation, which is to have the defendant submit to SATIF, withdraw the MTR and alter and amend his conditions for SATIF.
All right, so the MTR can no longer be withdrawn because he's already played.
That's right, Your
So-
Honor. I apologize.
No
But,
problem.
That's what we would recommend, is that he go to SATIF.
All right, so defense, what are you requesting?
Your Honor, exactly that. I just spoke to my client. He was under the understanding that he had a possession of drug paraphernalia when he did complete SATIF and does have a full-time job and understands he's going open to the court. He missed this one drug test because he couldn't get there on time. He has drug tested before and they've all come out negative. This is his first MTR. He seems to be doing very well on the deferred adjudication. He understands he's up in front of you with the full range of punishment and kind of going open to the court, but wanted to address the court and ask that if he could have a less structured modality that he could continue to work.
All right. Before you address me, any objection? I haven't opened it yet, but any objection to the court reviewing the court summary? All right.
Next. Or do you
Oh, yes, they emailed me.
Okay.
I receive it by email, but I don't open it until parties have no objection.
Now we see the defendant face the pressure directly. He admits a violation, pleading true, which hands the judge enormous power, up to 10 years in prison on the table. The state pushes for stricter probation, while the defense argues for leniency, pointing out his job, negative tests, and progress. Every word matters here, as both sides paint opposite pictures of the man's future. The judge listens closely, setting the stage for a dramatic decision.
All right, probation. What are you recommending?
The recommendation is for residential treatment at SATA followed by the aftercare and continued on the ISD case.
Is it possible to do, just do the aftercare portion, or has the time frame between being in SATA?
Well, he didn't do SATA the first time, Judge. He did local ISF.
Ah, okay.
So as we know, local ISF is more geared to cognitive, and then the SATA has that substance abuse. I was in the midst of looking up why he did not qualify for a drug court. If you would
Yes,
like to know that.
yes. And then you want to raise your right hand for me?
Yeah.
Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
My name is Christian Brown again.
All right, so it appears there's something you wanted me to
Yeah.
hear. Did you want him to speak to me, counsel?
That's his intention. It's your intention to address the court,
Yeah,
correct?
ma'am.
Yes.
I just want to let you know, ma'am, I understand this, what they're recommending. I just feel like, and you, it's been fair since I've been in your courtroom, ma'am. I already completed ISF, which is.
So here's the thing. Let's get to the crux of the problem.
Yes,
The
ma'am.
problem is you didn't report for your UA. Why?
One time, ma'am, I was
No,
there.
no, no. Let's not do the one time, because one time is enough. Wait. We have to speak one at a time. And so let me explain something to you. So don't tell me it was only one time. And the reason why I tell you not to tell me that is because those are conditions of your probation. One time for anything is enough for you to be revoked and sent to prison. So don't say it was just one time, because that's making excuses, right? Just tell me, why didn't you report?
Well, when I first got out, ma'am, I'm gonna get to that. I was doing well. I was remodeling home for my brother, and I was always in contact with my probation officer, and I had just lost my efficiency, ma'am, and so being in the streets, having my things stolen, lost the storage, and so and these are not excuses, ma'am, these are the truth. I had trouble with cell phone, and I always made sure I emailed when I didn't call her, and so fast forward to the motion to revoke, I had just over there, I want to say 7 days prior to the motion to revoke, because I hadn't been able to speak to her, and that's the reason why I missed it, because I'm having to deal with wanting to get shelter, and I was living in Fishkey, and I went to the hotel, and it was just hard, ma'am, and that's just all I can tell you.
Here's the thing. I'm going to give you a choice.
This pod explodes with raw tension. The judge zeroes in on the defendant's excuse for missing the drug test. He tries to downplay it as just one time, but the judge shuts that down instantly. One violation, she reminds him, is enough to send him to prison. The defendant pleads his struggles, homelessness, stolen belongings, personal chaos, but the judge cuts through the excuses. In this moment, you can feel the courtroom holding its breath as the outcome hangs in the balance.
These are your choices. There's no other choice, right? Here's your choice. I can revoke you, and I will sentence you to 2 years in the prison. That's one choice. Or either your second choice, I will continue you on probation. And what I'm going to do is it's going to be an intensive supervision. And I'm going to start you off with GPS. And that will be partial GPS for employment only. Those are your two choices. There are no other choices. Do you need to discuss that with your attorney?
No, ma'am. Could you please waive the fees on the GPS?
Yes.
Yes, ma'am. I can do it. I can do it, ma'am.
All right, Ms. Abrams, I'm going to deny the motion, alter and amend conditions to include partial GPS for employment only, waive fees, and intensive supervision with probation and intensive outpatient treatment with probation. Is there anything else?
Nothing from the speaker.
Ms. Abrams, is there anything else?
No, sir.
Anything else you need from the court to be successful?
You don't know everything is worth.
You're welcome. Anything else?
Can I just clarify, he's on deferred adjudication, correct?
Yes. All right, thank you.
Judge, thank you for all your consideration as
You're
well.
welcome.
Appreciate
You're
it.
welcome.
Finally, the hammer comes down. The judge gives him two stock choices: prison time or stricter probation with GPS monitoring. It's the ultimate ultimatum, and he quickly agrees to probation. The judge spays him but adds tough new conditions, making clear this is his last chance. The tension eases as the courtroom settles, but the warning is unmistakable. One more slip, and it's over. And that's it for today. Don't forget to like this video, subscribe to the channel, and we'll see you in the next one.